The amazing part of this vlog is not the relatively straightforward judgment.
It's the outrageous mental gymnastics of the CDC.
Viva Frei, Montreal litigator turned YouTuber, and this is Winnie the Westie looking at me for some reason. Some of you may already be aware of the order that the CDC issued a while back, a nationwide moratorium on evictions in the name of disease control. Well, some people took that moratorium to court to challenge its validity, and the judgment just came in. Yes, that moratorium was unlawful. Now, the judgment in this case is pretty straightforward. It's pretty obvious. I could have drafted it myself. What is truly fascinating in this case is the mental gymnastics of the CDC to have issued that moratorium in the first place. And on what basis did the CDC issue that moratorium in the first place? That it was necessary in order to stop the spread of COVID. United States District Court for the District of Columbia, Alabama Association of Realtors, al. Plaintiffs versus United States Department of Health and Human Services, al. Defendants. Memorandum of Opinion. As part of the Coronavirus Aid, Relief, and Economic Security Act, CARES Act, Congress enacted a 120-day eviction moratorium that applied to rental properties receiving federal assistance. After that moratorium expired, the U.S. Department of Health and Human Services, HHS, through the Centers for Disease Control and Prevention, CDC, issued an order implementing a broader eviction moratorium that applied to all rental properties nationwide. Since then, Congress has granted a 30-day extension to the CDC order, and the CDC has extended the order twice itself. The current order is set to expire on June 30, 2021. Okay, so you can see here that Congress enacted a moratorium on evictions of 120 days, but it was part of an economic relief package, and it only applied to rental properties receiving federal aid. In comes the CDC and decides to extend this moratorium to all properties nationwide, and their basis for doing it was apparently to stop the spread of COVID, but we're going to get there. In this action, the plaintiffs raise a number of statutory and constitutional challenges to the CDC order. Before the court is the plaintiff's motion for expedited summary judgment, as well as the department's motion for summary judgment and partial motion to dismiss. For the reasons that follow, the court will grant the plaintiff's motion and deny the department's motion. Now, just very briefly, because we will get to this a little later in the judgment, a motion for summary judgment is basically when the parties agree on all facts. There are no disputed facts among the parties. It is only a question of law for the judge to decide. No need to wait. You can ask for a motion for summary judgment to get the judge to issue a judgment. And the defendants filed a partial motion to dismiss, which itself was dismissed because the judge granted the plaintiff's motion for summary judgment. A quick overview of the background just for context. On March 13, 2020, then President Trump declared COVID-19 a national emergency. 2 weeks later, he signed the CARES Act into law. The CARES Act included a 120-day eviction moratorium with respect to rental properties that participated in federal assistance programs or were subject to federally backed loans. In addition, some but not all states adopted their own temporary eviction moratoria. On August 8, 2020, then President Trump issued an executive order directing the Secretary of HHS, the Secretary, and the Director of the CDC to, quote, consider whether any measures temporarily halting residential evictions of any tenants for failure to pay rent are reasonably necessary to prevent the further spread of COVID-19 from one state or possession into any other state or possession, end quote. Weeks later, on September 4, 2020, the CDC issued the, quote, temporary halt in residential evictions to prevent the further spread of COVID-19, end quote. Pursuant to Section 361 of the Public Health Service Act, 42 U.S.C. Section 264A, and 42 CFR Section 70.2. In this order, the CDC determined that a temporary halt on residential eviction was, quote, a reasonably necessary measure to prevent the further spread of COVID-19, end quote. The judgment then goes on to highlight some major differences between the CDC moratorium and the moratorium that existed under the CARES Act. Unlike the CARES Act's moratorium, which only applied to certain federally backed rental properties, the CDC order applied to all residential properties nationwide. In addition, the CDC order includes criminal penalties. Individuals who violate its provisions are subject to a fine of up to $250,000, 1 year in jail, or both, and organizations are subject to a fine of up to $500,000. The CDC order was originally slated to expire on December 31, 2020. As part of the Consolidated Appropriations Act, however, Congress extended the CDC order to apply through January 31, 2021. On January 29, 2021, the CDC extended the order through March 31, 2021. In this extension, the CDC updated its findings to account for new evidence of how conditions had worsened since the original order was issued, as well as, quote, preliminary modeling projections and observational data, end quote, from states that lifted eviction moratoria, quote, indicating that evictions substantially contribute to COVID-19 transmission, end quote. that is the background for context. The judgment then goes into the legal standard for granting a motion for summary judgment, and we can go over that very briefly. Summary judgment is proper if the moving party, quote, shows that there is no genuine dispute as to any material fact and the movant is entitled to a judgment as a matter of law, end quote. In this particular case, it's not hard to see how there are no disputed facts between the parties. The parties basically agree on all of the facts. It's only going to be a question of law, and the judge comes down with his judgment on that question of law. Section 361 of the Public Health Service Act empowers the Secretary to, quote, make and enforce such regulations as in his judgment are necessary to prevent the introduction, transmission, or spread of communicable diseases, end quote, either internationally or between states. Quote, for purposes of carrying out and enforcing such regulations, end quote, the Secretary is authorized to, quote, provide for such inspection, fumigation, disinfection, sanitation, pest extermination, destruction of animals or articles found to be so infected or contaminated as to be sources of dangerous infection to human beings, and other measures as in his judgment may be necessary, end quote. The Secretary is also authorized to, within certain limits, make and enforce regulations to apprehend, examine, and, if necessary, detain individuals, quote, believed to be infected with a communicable disease, end quote, or who are, quote, coming into a state or possession, end quote, from a foreign country. So the funny thing is the provisions of this Public Health Service Act sound a lot like Canada's Quarantine Act, and they basically give a broad range of powers to designated officers to do that which is necessary to stop the spread or the introduction of a disease. The question is whether or not a nationwide moratorium adds to that or is included in that power. And the judge says,
no.
The National Eviction Moratorium satisfies none of these textual limitations. Plainly, imposing a moratorium on evictions is different in nature than, quote, inspecting, fumigating, disinfecting, sanitizing, exterminating, or destroying, end quote, a potential source of infection. Moreover, interpreting the term, quote, articles, end quote, to include evictions would stretch the term beyond its plain meaning. So as not to be accused of strawmanning the CDC's position, there is something of a legitimate argument here. The CDC's objective, its purpose, its
raison d'être,
to speak a little French, is to prevent the further spread of disease. So hypothetically, in theory, if the CDC determines that a nationwide moratorium on eviction will slow the spread of a disease, why wouldn't that fall within their authority? And the judge simply concludes that this authority is found nowhere in the letter or the spirit of the law as drafted. Not only does the judge say that, but the judge says that never in the history of the CDC have they ever extended their powers to a moratorium on evictions. It is also telling that the CDC has never used Section 264A in this manner. As the department confirmed, Section 264A, quote, has never been used to implement a temporary eviction moratorium, end quote, and, quote, has rarely been utilized for disease control purposes, end quote. Quote, when an agency claims to discover in a long extant statute an unheralded power to regulate a significant portion of the American economy, end quote, the court must, quote, greet its announcement with a measure of skepticism, end quote. You have just gotta love that passage from the judgment. The judge is basically saying when an agency comes to court and says, look, whoa, we just discovered that we have the power to do pretty much whatever we want, the judge has to approach that declaration with a certain degree of skepticism. When an agency comes to court and says to the judge, look, we pretty much have the power to do whatever we want, it might be time for the court to say, no, you don't. The department advances one final counter-argument. It notes that subsequent subsections of the statute 264B to D contemplate that the secretary may, under certain carefully prescribed circumstances, provide for the, quote, apprehension, detention, or conditional release of individuals, end quote, who are arriving in the United States from abroad or who are, quote, reasonably believed to be infected with a communicable disease, end quote. And it stresses that enforced quarantines are not listed in and are different in kind from the measures enumerated in Section 264A. In sum, the Public Health Service Act authorizes the department to combat the spread of disease through a range of measures, but these measures plainly do not encompass the nationwide eviction moratorium set forth in the CDC order. Thus, the department has exceeded the authority provided in Section 361 of the Public Health Service Act, 42 U.S.C. Section 264A. The CDC raises another argument, that being that Congress actually ratified their actions so that they are somehow lawful now. In its partial motion to dismiss, the department argues that Congress ratified the agency's action when it extended the moratorium in the Consolidated Appropriations Act. And what does the judge say?
No.
Quote, Congress has the power to ratify the acts which it might have authorized in the first place, end quote. Congress did not do so here. When Congress granted a temporary extension of the eviction moratorium by enacting Section 502, it acknowledged that the CDC issued its order pursuant to the Public Health Service Act. It did not, however, expressly approve of the agency's interpretation of 42 U.S.C. Section 264A or provide the agency with any additional statutory authority. Instead, Congress merely extended the CDC order for a limited 30-day duration. Quote, mere mere congressional acquiescence in the CDC's assertion that the CDC order was supported by 42 USC section 264A does not make it so, end quote. Because Congress withdrew its support for the CDC order on January 31, 2021, the order now stands and falls on the text of the Public Health Service Act alone. For all the reasons stated above, the national eviction moratorium in the CDC order is unambiguously foreclosed by the plain language of the Public Health Service Act. The judge then discusses what would be the appropriate remedy now that we have declared the moratorium to be unlawful. It seems the parties agree that a vacator of the order is appropriate, except the CDC is asking only for a vacator as relates to the parties before the court. Both parties agree that if the court concludes that the secretary exceeded his authority by issuing the CDC order, vacator is the appropriate remedy. For those of you who may not be up to speed on your Latin, vacator means the following. Vacator is a Latin term which means, quote, to set aside a judgment, end quote. So while both parties agree that a vacator is the appropriate remedy, the department only wants that vacator to apply to the parties before the court and not the nation as a whole, to which the judge says,
no.
Nonetheless, the department urges the court to limit any vacator order to the plaintiffs with standing before this court. This position is, quote, at odds with settled precedent, end quote. This circuit has instructed that when, quote, regulations are unlawful, the ordinary result is that the rules are vacated, not that their application to the individual petitioner is prescribed, end quote. The court ends the judgment by explaining and highlighting the importance of the separation of powers of the respective branches of government. The court recognizes that the COVID-19 pandemic is a serious public health crisis that has presented unprecedented challenges for public health officials and the nation as a whole. The pandemic has triggered difficult policy decisions that have had enormous real-world consequences. The nationwide eviction moratorium is one such decision. It is the role of the political branches and not the courts to assess the merits of policy measures designed to combat the spread of a disease, even during a global pandemic. The question for the court is a narrow one. Does the Public Health Service Act grant the CDC the legal authority to impose a nationwide eviction moratorium? It does not, because the plain language of the Public Health Service Act 42 USC section 264A unambiguously forecloses the nationwide eviction moratorium. The court must set aside the CDC order consistent with the Administrative Procedure Act 5 USC section 7062C and DC Circuit precedent. For the foregoing reasons, the plaintiff's motion for expedited summary judgment is granted and the department's motion for summary judgment and partial motion to dismiss are denied. A separate order consistent with this decision accompanies this memorandum opinion. That is the judgment. We will see if this goes to appeal, but imagine it had to go to court in the first place in order for a judge to tell the CDC you do not have the authority to declare a nationwide moratorium on eviction. We will also be discussing this during the next live stream with Robert Barnes, but if you like my videos, you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below because it feeds the algorithm. If you want to support the channel, all of these support links are in the pinned comment. We've got PayPal, Patreon, Subscribestar, YouTube membership. We've got merch. Robert Barnes and I do live streams every Sunday. We do weekly streams every Wednesday with a guest called The Sidebar. We have a page on locals. It is called
Viva Locals.com.
All of my content is also on Rumble, so you can check it out there. But more important than any of that, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out. Booyah.